The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
Good afternoon and welcome to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris and Shay DuPont with you as we are every Saturday afternoon from 2 until 4 o'clock on our flagship station, 610 WIOD and 970 WFLA. The number is the same. Call the show if you've got a question or concern. You want to tell us your story. You need some assistance. That's why they're here. They're here for you. 866-610-NEWS. That's 866-610-6397. AT&T Wireless customer star 610. It's toll free to call the Home Mortgage Law Show, sponsored by Morris DuPont PA. You'll find us by that name on our Facebook page and also Morris DuPont PA on Twitter.
And today we're going to be talking a lot about short sales. Last week we talked a lot about loan modifications, and I tried to go over the steps of how you can qualify for a loan modification, and if you're able to qualify for a loan modification, what kind of results you should see. Remember, a loan modification is where your lender modifies the terms of your existing mortgage and can take your interest rate as far down as 2%. And today we're going to be talking about short sales. But first, let's talk about a little bit of news that's come out this past week. We know, of course, about the national mortgage settlement that occurred last March of 2012. That was when the 5 large lenders settled with the Department of Justice and 48 attorney generals around the United States and agreed to pay a fine, basically a settlement of over $25 billion in fines for wrongdoing through the foreclosure process. Well, the banks have now agreed that they have actually given out over $50 billion worth of relief as part of their obligations under that mortgage settlement. So we've got Bank of America, JP Morgan Chase, Wells Fargo, Citigroup, and Ally Financial, which was servicing your mortgage under the name GMAC. They've provided $50.63 billion in consumer relief to over 621,000 borrowers. That comes out to about $81,000 per borrower. So imagine in this past year, if you had applied for a loan modification or you had applied for a short sale, chances were you were going to get a principal reduction as part of that loan modification. And if you did a short sale, the lender was probably going to waive the deficiency if it was one of these 5 lenders. Now, Bank of America is saying that they have fulfilled all of their obligations under the national mortgage settlement, but they are going to continue to provide that type of relief to their borrowers, meaning that if you can qualify for a loan modification where the lender would be required to reduce the principal to create an affordable payment for you, which would be approximately 31% of your gross income, then they are going to reduce that principal, meaning they're going to actually forgive some amount of principal. Now, let's talk about forgiveness of principal. Remember, that is a taxable event because you borrowed a certain amount of money. Let's say you borrowed $200,000, and through the short sale, the lender is only getting back $150,000. They will issue you a 1099-C for cancellation of debt, which is considered income to you, and the IRS would typically tax that income as just basic straight income to you. But we know because of the Mortgage Debt Forgiveness Act of 2007 that when you do these events on your primary residence, that the lender is going to issue the 1099, but in fact the IRS is going to forgive the tax consequence on that if, again, it is your primary residence. And this is true for short sales. So let's talk a little bit about short sales today. What is a short sale? How is a short sale done? What are the different ramifications of a short sale to your credit score? What are the ramifications on being able to qualify for a mortgage going forward? And what is the process? How long does it take? A short sale, by definition, is, of course, selling a property for less than the value of the mortgages that are on that property. Now, many people have more than one mortgage, but today I will be basically focusing on a one mortgage property, but this will hold true for a two mortgage property. And if you have questions about a mortgage or questions about your property and it has one then more, I don't know why I'm a little buttery today.
A little bit.
I'm talking really fast, I know.
It's a lot of information. What I am getting out of it, though, is can a person file for all of these tax-exempt programs by themselves, or is it better to get an attorney?
Well, when you're getting a 1099 issued by your lender and you believe that you have a tax consequence on that, which you normally would, you should be talking to your tax advisor, actually, your CPA. We, of course, use Regal Tax Advisory Group. Regal Tax Advisory Group has been very helpful to many, many clients of Morris DuPont. You know, Natalie, what's interesting is we had a prospective client come in last week, and they talked about some of the issues they had in a prior short sale that they had done and the tax consequences on it. But it kind of raised a couple of red flags because it wasn't at the time of the short sale their primary residence. But by definition, I know that primary residence is defined as a residence you lived 2 of the past 5 years in, and they had lived in that property and 4 and 5 years ago, yet they had moved out because it was no longer affordable, and they actually had to rent that property, and then they realized even renting it, they couldn't afford to keep it. So consequently, they did a short sale on it, and they had a tax consequence on that. And I was like, well, wait a minute. That doesn't seem to make sense. So I actually sent them over to Regal Tax Advisory Group, and Regal Tax Advisory Group was actually able to get them a refund of $5,000. They amended the 2012 tax return, and they were able to get a refund of that amount because, in fact, it was categorized as a primary residence, and they submitted Form 982, which you submit with Form 1099, and the IRS then waives the tax consequence on that because they were getting a principal reduction on a property that had been considered their primary residence. So that's sort of an interesting aside.
Good.
So when I talk about short sales today, I'm going to be talking about a property that has one mortgage on it to make it rather simple. But again, if you have a property that has more than one mortgage on it, maybe you've got a HELOC, a home equity line of credit, or you have other liens on the property. Maybe your HOA, your homeowners association, has actually filed a lien, and that is attached to the property as well. Give us a call at the Home Mortgage Law Show, and I'm happy to talk about individual, more complicated short sale situations that you might have gone through, or you might be going through today, or you might be anticipating that you would have if you tried to short sale your property. So we'll try to talk about short sales today, although we've got Michelle Hanash in with us today, so I know we're going to have some bankruptcy too. But
we have a bankruptcy story, I'm sure.
I'm sure we will. So after the break, we'll talk about that as well.
There you go. And the Regal Tax Advisory Group information, I just put it up on our Facebook page, the Home Mortgage Law Show, sponsored by Morris DuPont, PA. Once again, the number to book your free consultation while we go to break is 1-800-974-2712. 1-800-974-2712. Phones are already ringing off the hook here on the Home Mortgage Law Show. First call will be Tom right after the break here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, joined today by Michelle Hanash, our bankruptcy attorney. Our phone lines here in the studio are open and toll-free to call us, 866-610-NEWS. That's 866-610-6397. AT&T Wireless customers, star 610.
And I'm happy to see Michelle Hanash here in the studio with us today. Michelle Hanash is a bankruptcy attorney with the law firm of Morris DuPont. Michelle, I love it when you come in because you're able to integrate bankruptcy with loss mitigation. We have a lot of people that come to the firm and tell us that they already had a consultation with another law firm, and it's a law firm that mostly does bankruptcy. And guess what that firm told them was the only solution to their housing problems?
Was bankruptcy.
Filing bankruptcy, right.
Which can be a great solution, but I think one of the best things that we have to offer is that no one is going to pigeonhole you in one area to solve your problems. Even in just my department, we come in and we do an analysis if you can actually do some type of debt settlement, perhaps, in lieu of a bankruptcy. But if bankruptcy is the better option, then we go with bankruptcy.
Sure.
Absolutely.
Sure. Do we have a case of one of the records in the office was a case we just took on a guy who foreclosure was filed against him in 2001. That was 12.
I'm sure I heard that wrong.
That was 12. Yes, 2001. 12 years ago. He had filed a couple of bankruptcies. He actually seen Ziona up in Tampa to see whether or not he can file another bankruptcy.
And he actually thought bankruptcy was his only
It
option.
was his only option. We actually got the sale canceled because he's got a modification application pending and they're reviewing it.
Yay.
A 2001 case.
And
So-
yet, all along, he'd been getting legal advice.
That the bankruptcy is the only way out. And turns out it is not.
Of course not.
So
And it's not his best option. I know
Actually, it was-
exactly who you're speaking
Right.
about, and absolutely the loan modification and trying to work something out with the lender outside of a bankruptcy was much better for him.
right, absolutely.
So there you have
I
it.
didn't think we could do it. Look, quite frankly, I was a little scared to go before a judge and say, "Listen, judge, this is a 2001 case. I'd like an extension of the sale date."
But if anyone can do it, you can do
I'm
it.
surprised he didn't throw me in jail.
Well, you saw up on the board up in the loss mitigation department this week that we actually got a loan modification also for someone who was 55 months past due.
Wow.
And
Let
we
me do the
got-
math. That was almost like 10 years.
Oh, God.
No?
A little less than
God.
5.
Oh, thank you, Michelle. Thank you, Michelle. Yes, a little less than 5 years. They had defaulted on their mortgage. They had a foreclosure action filed against them, and the lender just basically kind of abandoned the foreclosure action.
Right.
And so, they're like, well, we're kind of in limbo. And so we took a look at it and we said, we think you're a great candidate for a loan modification. We submitted the loan modification application. And we, again, 55 months past due, we got them a principal reduction.
Nice.
I think it was $91,000 in a principal reduction. So we actually got them a little over $20,000 in positive equity on the property.
Wow.
I know, it was pretty crazy.
Awesome.
So, great results this week.
Yeah, it was a good. I heard that horn going
That's
off
what I
quite a
was
few times
just
this morning.
about to say.
there's a bullhorn that blows every time there's a modification done, and it's been going crazy this week.
I know there's some people in the foreclosure defense department who feel as though every time they get a sale canceled, they should get to blow the horn.
Well,
Yeah, we should get our own horn.
you should.
Something should be blown in the foreclosure department.
Let me explain a little bit to the listeners. At Morris DuPont, we have in the loss mitigation department an air horn, just like you use, on a boat. And anytime any of the loan mod consultants get someone a loan modification done, right? They get a permanent modification. The paperwork comes in. They blow the horn so that we all come by their desk throughout the day and ask them for the results. And they are able to brag about the great results that they got for a client because we're all sort of emotionally involved in this.
Sure.
We love to win. We love to get great results for our clients. You have a lot of interaction with the client, so you get to know them
You
personally.
get personally vested in the whole thing,
Right.
you know?
So it's really great. And then once a week, the best result of the week gets to go up on the dry erase board and all the specifics of what that person was able to get for that client. So we all go by and write comments on the dry erase board. And, I was circling that 55 months and putting
Right.
stars around
Right.
it. Congratulations. So, it's really exciting that we're able to help people like this and see these kinds of results. I was talking about the national mortgage settlement and the kind of results that people have gotten in the past year. I mean, that was helping over 621,000 borrowers throughout the United States that were able to get principal reductions, that were able to get 2% interest rates. It's not a refinancing. It's not HARP. It's under HAMP, typically, the Home Affordable Modification Program, that we're able to see these kinds of results for our clients and get them the terms of their mortgage modified, not a new mortgage, but tweaking the interest rate, the principal balance, and the term of the mortgage, and that could see a savings of as much as 30 to 40% reduction in your monthly mortgage payment. I know we've got some calls. Oh, we missed Tom.
Well,
We did.
I had a question about the settlement. Now, I was reading something recently that said that most of the banks that are involved in the $25 billion settlement in early 2012 have essentially complied with all the requirements under the settlement. They've given enough modifications and principal reductions to satisfy the dollar amount. Do you think that's going to affect the ability for borrowers to see principal reductions going forward now that the banks have completed the requirements under the settlement agreement?
That's a great question, Will, because we know that Bank of America has announced that even though they have complied with the terms of the settlement and they have paid out in terms of principal reductions, either on a loan modification or forgiveness of the underwater portion on a short sale, Bank of America has seen such positive results from doing this that they're going to continue to do this. Because remember, there's a lot of studies out there that say that principal reductions actually are good because it allows people to stay in their home. They now have a payment that is affordable going forward, and it's good for the economy. So Bank of America is now seeing the results because they've been doing this for over a year, and we already knew because those same studies were used against Edward DeMarco, who is the head of the
acting director.
Well, yes, that's right. The acting director of the Federal Housing Finance Authority, because he will not allow principal reductions on Fannie Freddie loans. And all these studies were coming out saying, but principal reductions are positive for the economy. So why won't you agree to them? But he's just being
I'm not the smartest person in the world, but I've been saying that ever since the day we first got on the radio
4 years ago.
That, listen, principal reductions, it has to be the answer. This is the only logical solution there is. And now, luckily, smarter people than me have finally concluded that this is the way to go. And unfortunately, Mr. DeMarco doesn't see it that way. But the good thing about it, he's not going to be around too long to continue his policies.
We can only hope. Yeah. You know what's bubbling back up to the surface is that shared appreciation program. Ocwen, so if you have your loan being serviced by Ocwen has a very unique program, and it's called the Shared Appreciation Program. Ocwen has been offering this to our clients for the last 3 years, but you don't hear much about it. The Shared Appreciation Program is where Ocwen says, all right, borrower, you have suffered a financial hardship. You have negative equity on your property. We will agree to reduce the principal, forgive the principal on your mortgage down to the current market value. But if in the future, when you sell that property, there is positive equity on that property, we want a percentage of that. We want some of that principal that we forgave back, not all of it.
Sure, only fair, I think.
Exactly. That is a great program. So if you do have positive equity later, why shouldn't the lender that agreed to forgive principal in the past be able to share in that? Because it only seems fair. So there is talk again, not of other entities looking at what Ocwen has been doing with the shared appreciation program and the positive results that they have gotten from it to say, well, wait a minute, maybe we should revisit this with other servicers and see about instituting some other shared appreciation programs across the board. I know we've got some calls.
We do. Leonard, welcome to the show.
Hi, Leonard.
Hi. I have a fundamental kind of basic question. We got a lot of returning vets, men and women. What advantages, if any, are there in securing a VA mortgage over a conventional mortgage?
Well, there is a really great program for returning vets, and let me give you the categories. Active duty military, former military, disabled veterans, and Civil Service Department of Defense employees. And this program is called HAP, HAP, Homeowners Assistance Program, and it is granted to eligible service members as well as Federal Department of Defense civilian employees. It's a program that was established by law and is enforced by the U.S. Army Corps of Engineers. And what it does is it offers assistance to homeowners who fit the program's eligibility criteria and are suffering financially, and they are in the process of selling their VA homes as well as struggling to pay back the full amount of their VA loan. Now, if you qualify for this program, this program will actually pay that the deficiency amount, and they'll do loan modifications, and they'll do some great results. And if you go through that program, you will immediately be eligible for a new VA loan. So we've got to take a break, but when we come back, I'll expand on that a little bit.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. 800-974-2712. 1-800-974-2712. That's a free consultation at the law offices of Morris DuPont. After the break, more calls here on the Home Mortgage Law Show. Listening listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, and our bankruptcy attorney Michelle Hanash here for you. Toll free to call the show, 866-610-NEWS. That's 866-610-6397. AT&T Wireless customers, all you have to do is dial *610.
And before the break, we had Leonard who called in. Of course, we just had Memorial Weekend, and we had Memorial Day last Monday honoring our vets. And Leonard had a very timely question. What programs are available out there that are going to help military, those vets, those people? And there is a great program, and it is called HAP, H-A-P, Homeowners Assistance Program. It is through the U.S. Army Corps of Engineers. Isn't this interesting? Mm-hmm. We've got this very specific program that is there to help not only military, but also Department of Defense employees. So you can be a civilian and also qualify for HAP, but it really is for people who are associated with the military and they are suffering a financial hardship or they have an underwater property, and let's say that they want to short sale their home. Well, this program will cover, as you said, Will, the deficiency amount. It will also help in other ways. And when you finish all of that, you will still have your VA eligibility, and it'll be immediately restored.
Right. That's an awesome benefit.
Right, allowing you to go and buy a new home with zero down and using your VA home benefit.
Right. Normally, when a person short sells a property, if it's an FHA loan, they have to wait 2 years before they're able to qualify for a mortgage.
Oh, yeah,
In this
three.
instance,
Three.
Right. In this instance, they can immediately qualify for a new mortgage. Listen, that's the least we can do for our veterans, really.
Absolutely. So, you need to know about all these programs, you think, but you don't. You just need to know about the law firm of Morris DuPont, because we know all about these programs, even these niche programs that are available for certain segments of the population. We are aware of these programs. We know how to qualify for them. In fact, in this program, it becomes very specific because you actually have to have a VA HLC approved realtor involved in the short sale. So there's a lot of little ways that this could be tripped up. But if you use a law firm such as Morris DuPont, who understands loss mitigation, who knows all the programs, you know that you will be able to take advantage of any program that you could possibly qualify for, including HAFA, which could give you a relocation incentive on your short sale of $3,000. Wouldn't that be great?
That would be great. Which reminds me of the extension of HAMP. But before we do that, we should tell people how they can get in touch with this law firm.
That's a good idea. Well, let's do it. 800-974-2712. So you can call that number toll free. That's 800-974-2712. Remember, if you can hear our voice, there's an office nearby. We've got St. Petersburg, Tampa, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, Boca Raton, and West Palm Beach. If you're not close enough to meet me at one of those offices, I'll do a telephone consultation with you and see if there's some way that we can figure out what exactly is going on today with your mortgage and what are the possible options you have going forward. You've got an investment property, you've got a vacation home, your primary residence has negative equity. Let's talk about it. Free hour consultation. We're happy to sit down with you. I will be in the St. Petersburg and the Tampa office this coming week. Happy to schedule an appointment with you. Call the office and we can meet and we can discuss your specific situation. Again, that's 800-974-2712. If you're driving, don't worry. Just remember Home Mortgage Law. That's homemortgagelaw.com. That's the website for the law firm of Morris DuPont. If you go to homemortgagelaw.com, we also have a frequently asked questions tab on there. You can actually schedule your appointment through.
And soon we'll have videos.
Oh, I don't know, Will.
Yeah, stop
Let them
it.
use their imagination.
Stop it. See, you always find that good-looking people always complain about their looks?
I know.
Isn't that sad?
Jay.
I'm not videogenic.
Stop it.
Let's hit the phones. Joseph, welcome to the show.
Hi, Joseph.
Yes, hello.
Hi.
Yes.
What can we do for you today?
Well, I had an inquiry. I have been doing pro se defense against my own foreclosure on my property. It's been since March of 2009 that I've been doing this, and I filed bankruptcy in August. I was discharged last year, and I'm still in my house.
Okay. Congratulations. What's your question?
Well, basically, I'm wondering why there is no movement on the on the dockets as far. It looks like I fell in between the cracks again.
What chapter in bankruptcy did you file, first of all?
Bankruptcy Chapter 7,
Okay.
and I was surrendering the home.
So what your call brings up is the issue in a Chapter 7 where your personal liability is discharged
Right.
in regards to your mortgage note, not the actual mortgage lien.
Right.
Meaning,
meaning
you
the
can
bank
stay
is still
in the
you
house.
can stay in the house until the bank
Exactly.
forecloses and essentially get a writ of possession, and then you can leave and walk away without any concern of them being able to come after you because that personal liability has already been discharged in bankruptcy.
Exactly. And this caller
Correct.
shows how long that process can take and how long you can actually be in that home after your bankruptcy discharge.
But Joseph, I like the phrase that you used. You fell between the cracks. Michelle and Will, we've seen this time and time
All the
again
time.
where someone has filed a Chapter 7. You can get in and out of a Chapter 7 in possibly 4 months.
Right.
Yet maybe the foreclosure action was filed against you. You filed a Chapter 7.
They stopped the
It
foreclosure
stops the
action.
foreclosure.
It stays the foreclosure.
Right.
And then suddenly the lender seemingly forgot all about you.
Forgot about
and
it.
they're not moving the foreclosure
Exactly.
action forward. They haven't filed a pleading
Right.
in possibly 9-10 months.
It happens all the time
This
because
happened actually to a client of ours whose house was already sold.
right. Look, right. It happens
It
all the time. Right.
stopped.
It stops everything.
I would like to say something. I'm against the institution of the banks, and I've defended myself. And I've gone from one bank to another bank, from another bank. I've hit him with residence bond 3 times in a row.
What do you mean? Oh, okay. The non-residence
I
bond.
really fight.
Look at this guy practicing law out there. Good for you.
No, I do my own paperwork and everything because I'm in the business in the real estate.
Okay.
But the thing is, at this point, I need to. What happens if I say, well, I want to do a short sale?
Well, why would you? What's the motivation of doing a short sale?
If he wants to exit the property.
Listen. The reason to do a short sale is to get that deficiency waiver, right? The difference between what that you owe to the bank and what the property is worth. If you've already gotten discharge of personal responsibility regarding this debt, there's no reason to get a waiver of deficiency, and there's no reason
Unless
to pursue a short
maybe
sale.
he wants
Or
to
maybe,
move.
unless,
To exit,
unless,
maybe he wants to
unless,
move
Let's
on.
ask Joseph.
unless you want to move.
Joseph.
What do you want to do?
Why?
What if I want to change? What if, for example, I want to change my bankruptcy into keeping my house at this point?
The bankruptcy isn't involved. Your bankruptcy was not involved in whether or not you were keeping your home. It wasn't a bankruptcy that helps you get caught up on your behind mortgage payments. That would be a 13. And if, in fact, you did want to try and get current, not discharge debt, you could actually file a 13 to help you get caught up on your payments to keep the home. But you, as you know, still own your home. You still have loss mitigation tools available to
Right.
you, including perhaps a loan modification,
Right.
because you still own your home.
Right.
You just don't have personal liability on the note, and they will still review you for a loan modification, even though you were discharged in a bankruptcy.
All right, so let's make clear, Michelle. If Joseph now wants to keep the property, we can submit a loan modification application
Sure.
for him, and when and if he is able to qualify for a loan modification, and we can get the mortgage modified so that he's got a 2% interest rate and maybe a principal reduction if he can qualify, and maybe the term stays the same, maybe it has to be extended out. Will he have to reaffirm that debt?
No. In fact, I have not seen one client who was forced to reaffirm a debt. It would actually be improper to reaffirm a discharged debt without court approval, generally speaking. So the lenders are usually very clear in the documents that this is not a reaffirmation of the debt. It's simply a modification, and you're doing this because you want to. No pressure. You can send
Right.
the payments. You don't have to send the payments. We're not going to collect against you. And that works out.
And so if he gets a loan modification and he signs off on that, he is not, again, accepting personal
No.
responsibility on the note. What he is doing is getting his mortgage back in place, performing, so the foreclosure will be dismissed, and he will go on for maybe the next 25 years making a mortgage payment. But at some point, if he wants to sell the property and he has negative equity on that property, he's not going to have to worry about a deficiency waiver because he was released of that personal liability on the deficiency amount in the Chapter 7 that might have happened 5 years previous, right?
Correct. Exactly.
Does that make sense, Joseph?
Well, yes, it does make a lot of sense, but what doesn't make sense is that they keep billing me for all the unpaid late fees of a total of $95,000.
Of course they would.
They're pursuing me.
Well,
What do you mean pursuing you?
Apart, they're pursuing me they're sending me letters at this time, and they're basically asking me to repay the outstanding balance, which is like $95,000.
Well, Joseph,
we're going to spend late fees.
We're going to spend the break talking about your case, and when we come back from break, we'll give you our advice.
Well, okay, good, great. Thank you.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. 800-974-2712. 1-800-974-2712. That's the number for free consultation at the law offices of Morris DuPont. If you can hear our voices, there is an office near you. Pick up the phone and call. It's toll free. 1-800-974-2712. More of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. It's 866-610-6397. This toll-free number here in the studios, 866-610-6397. Just we're waiting to get on the phone with Joseph and had a little technical difficulty, and I think we lost him, so maybe Joseph will call us back. But we were discussing his case here on the show.
And actually, Michelle, when we went to break, Michelle actually got on the phone with him privately and spoke to him a little bit more about his case. Because we were having difficulties because he said he was still getting invoices or bills.
Or that they were going after him.
Right,
yes,
right.
they were going after him, and that didn't seem right.
No, and so as it turned out, those statements being sent to him had language on there stating this is for informational purposes only, to be sure that they weren't violating bankruptcy law by trying to collect on a discharged debt. What I was explaining over the phone is that if you want to keep your home, you have to pay the mortgage because the lender can still go forward with a foreclosure even though your personal liability on the note had been discharged in a bankruptcy.
Well, let's take some time and explain that. Sure. The person, when you say the debt has been discharged, does that mean the bank, can no longer get payment? They're done for? What happens to the lien on the property? What happens there?
In a Chapter 7, when you do not reaffirm the debt, which is usually what happens when someone's filing a Chapter 7, especially when their house is underwater, their personal liability on the note is discharged. The mortgage lien remains, so that if you do not pay the mortgage, the bank can still go and foreclose on the property.
So if Joseph does nothing,
cannot collect personally against you.
Right. So if Joseph does nothing with regards to making payments on this discharged debt, the bank can still pursue him on the foreclosure side.
Exactly.
And the fact that they're not doing it might only mean that because there was a stay that is a result of filing bankruptcy, the bank may have forgotten about it and fell through the cracks.
Exactly.
And at some point, they're going to realize that this guy's been discharged from a bankruptcy, and they could go forward with their foreclosure lawsuit.
But, Will, that raises another question.
How long?
If the lender does nothing for a year, then does Joseph then have the right to file a FWAP and try to get the case dismissed without prejudice?
He could, but it's been my experience the minute you raise that red flag, of course you've got to give the bank notice that you're doing that. They're going to do something to keep the lawsuit going.
All right.
Yeah, sure you could. I mean, and hopefully if his case is really falling through the crack, maybe they wouldn't realize that he's filed this motion asking the court to dismiss the lawsuit because for lack of activity. Yeah. And that's what the FWAP is all about, failure to prosecute. So, that might be an option, but usually what happens is the bank says, whoop, we need to do something here, and go ahead and file something and keep the lawsuit going.
So we've got Joseph back with us. So, Joseph, how long has it been since there's been any activity in your foreclosure case?
Oh,
that sounds like a long
time. Sounds like a long time. That's a long time, Joseph.
All righty then.
October 12 of last year.
All right, so you're going up on a year pretty soon.
Going up on a year, right. Shay was suggesting that, if after a year, actually it's really 10 months.
10 months, yeah.
Yeah, after 10 months where the bank has done nothing with regards to moving the foreclosure lawsuit forward, you can try and see whether or not you can file a motion with the court and asking the court to dismiss for failure to prosecute. You follow?
Yes, at the same time I'm ringing a bell and then...
Exactly, that's the risk you run.
Yeah,
But
that's
if
true.
you really want to keep the house, maybe you want to run that risk. Look. If you want to keep the house, there's options available to you, like Shay was talking about before. You can still go ahead and submit a modification application and see what goes from there.
And also, I even like short sale for people who've gone through bankruptcy and have been released of the personal liability on their home, because short sale, number one, future lenders like that much better than for a property to go all the way to a foreclosure sale.
Right.
They want to see that a borrower has actively tried to help the lender to dispose of the property. Remember, the lender doesn't want your property. They don't need any more REO property.
Right.
They want you to sell the property for them and them to get the proceeds.
Well, they
of
make
the
more money
sale.
that way too.
Well, yeah,
Right.
and they're in the money business. So if you participated in a short sale, great. You don't care what the short sale approval letter says because you've already been released of the liability on the deficiency amount. So waive the deficiency, don't waive the deficiency.
cares?
I don't care. I've already
Right.
been released of it in my Chapter 7 bankruptcy. What I'm doing is I'm facilitating a proper sale of the property to another person. It isn't empty. It doesn't hurt my neighborhood. Nobody's going to come in and trash it. So it doesn't turn into a property that went through a foreclosure sale, bought back in by the lender, and it sits there empty for months, and it hurts the neighborhood and,
Right.
could possibly be the subject of vandalism. So even if you do want to exit the property, Joseph, I'd still rather see you do it through a short sale. A deed in lieu is another option, but that is much more difficult. People think deeds in lieu, basically just handing the keys over to the lender,
A lot
is
more
an
tricky
easy
than that.
process. It is not. It is difficult. We don't like them. They take a long time, Michelle.
And don't forget that before that title transfers, however it does eventually transfer, you are on the hook for certain post-petition expenses and liability.
Such as
With
the
the
homeowners
property.
association
Taxes.
fees.
Exactly. If there's some city kind of
Liens or anything, right? Violations, right? Sure.
So
because
Joseph-
you're still a title owner,
exactly.
right?
So, Joseph, you do have a lot of options. You do have a different ways to go. You were able to not only wipe out your personal liability on the note, but any credit card debt, any other unsecured debt that you have. Maybe even in a Chapter 7 where they're stripping now second mortgages,
Second
Michelle?
mortgages, yes, it varies depending on which district you're in and even sometimes which judge. But it's moving towards, while we're waiting for, as you know, well, as the listeners may not know, there is a case.
They may not. They
an
may not,
11th
Michelle.
Circuit case pending appeal currently, which decided that in Chapter 7s we are allowed to strip off unsecured second mortgages, which usually and throughout most of the country is reserved for Chapter 13s. So these are very routine in the Middle District.
This would be huge.
That's huge.
Huge.
That's a
Huge.
huge thing.
And down here in the Southern District, it might depend what judge you're in front of.
Okay.
But it's really an amazing option, and
Sure.
it really might be the window of time to get it tried, at least, to
Right.
get your second mortgage stripped while this case is pending.
You want to guinea pig a case there, Michelle?
Sorry?
You want to do the guinea pig case?
I would love to.
Absolutely. I know Michelle would love to do one
Right.
of those. So, Joseph, do you have any other questions for us? I hope we've
Oh,
gone
yeah,
through.
I have another question.
Bring it on.
Let's go.
I'm wondering if you guys knew anything about the statute of limitations after they do this discharge on the bank side if they don't act. Is that the 12 months you were mentioning?
No. What you're talking about is a statute of limitations to prosecute a foreclosure lawsuit, which is normally 5 years. Now, once the foreclosure lawsuit is actually filed, that stops the statute of limitations from running. So it doesn't matter how long the case stays dormant. What Shay was talking about is what is called a FWAP notice, a failure to prosecute. Now, if a person doesn't move a case on within 10 months, a case remains dormant and nothing happens. That means the case has already been filed, but nobody's moving it forward. If it remains dormant for 10 years, the opposing part, 10 months, the opposing party, 10 years, the opposing party may petition the court and asking the court to have it dismissed for lack of prosecution, or the court may do so at its own initiative.
Right. But you're asking about the statute of limitations, and your statute of limitations argument stopped the minute the lender filed that foreclosure action against you. They were within the statute of limitations period, so there's no statute of limitations argument for you unless you get this case dismissed and then the statute of limitations starts to run again. Make sense, Joseph?
No, it makes a lot of sense because I actually went out and rented a house. My first question before I negotiated the rent with the owner was, "Are you in foreclosure?"
Mm-hmm.
And he lied to me. He told me no, and I went ahead. I
Shocking.
negotiated, and then after I moved into that other house,
Right.
I found out that he was in foreclosure.
Right. You know what? You want to hear my 2 cents advice? I would go back to him and renegotiate the term of your lease. How much you're paying on the
I would
on the lease?
stay in the house that he owns and isn't currently paying rent on.
No, right. That's too. That too. I would probably do that. But he's already gone.
Well,
No,
we've
but
got.
I didn't think that the banks can pursue me, but I think I was going to be a victim on my new landlord.
Well,
Rob-
Joseph, we're at the top of the hour. We've got a break. If you have more questions, remember, call us at the office and we'll be happy to help you.
And that number's 1-800-974-2712. 800-974-2712. Sabrina, Mike, Roy, getting to your calls after the break here on the Home Mortgage Law Show.